Good evening, everyone. Welcome to the sixth Open Forum of the Slynn Foundation, a foundation which is named after Lord Slynn, who was very dedicated to the rule of law across Europe and promoted that principle in all the different aspects of his career. We have a fascinating topic this evening about the future of the judiciary in Poland. I'm Vivian Rose, I'm a Justice of the Supreme Court in this country, and I will briefly introduce the speakers this evening, and then we will hear from them. First from Minister Adam Bodnar, then from Christopher Vajda KC, and then from Charles Crawford. And then we'll hear a little bit from Stephen Irwin, who is the chair of the Slynn Foundation, about the foundation, and to have some questions from the audience. So welcome very much to Minister Bodnar. He was elected as a senator in the 2023 Polish parliamentary elections and was appointed to serve as Minister of Justice by Donald Tusk that year. Before that, he served as the Polish Ombudsman, and his legal career covers academic posts in the Faculty of Law and Administration at the University of Warsaw, at the Polish-Japanese Academy of Information Technology, and as Dean of the Faculty of Law at the SWPS University in Warsaw. He's also spent several years working for a major international law firm. He's received many awards and accolades for his work in the field of human rights, including the Rule of Law Award conferred by the World Justice Project for his, quote, outstanding efforts in strengthening the rule of law in difficult circumstances, close quotes. And we're very honored, Minister, that you've agreed to speak to us this evening about those difficult circumstances and the challenges of addressing them. Christopher Vajda KC had an outstanding career as a barrister practicing in Monkton Chambers, where I had the pleasure of getting to know him. He was, of course, the UK judge on the Court of Justice in Luxembourg between 2012 and 2020, and he served as president of a three-judge chamber on various occasions. Since returning to Monkton Chambers following Brexit, he's been much in demand as an arbitrator and expert witness. He's been appointed to the panel of recognized international market experts in finance, and also the sports resolutions panel, and also to the panel of persons suitable for appointment as chairpersons for arbitrations to which the EU is a party. It might be some very interesting work. He's a visiting professor at King's College London and has kept up his connection with Luxembourg by being a lecturer in private international law at Luxembourg University and a member of the Bar of Luxembourg. Charles Crawford qualified as a barrister before joining the Foreign and Commonwealth Office in 1979. His first posting was to communist Yugoslavia, and he served at embassies in South Africa, Sarajevo, and Belgrade. He was the British ambassador to Poland between 2003 and 2007. He left the FCO at the end of 2007 to start a new career as writer and communication consultant, and he's also a former trustee of the Slynn Foundation, all of which means that he's highly qualified to speak to us this evening. And in addition, he has twice won the Cicero Award for speech writing, so we're all the more looking forward to what he's got to say. So may we start, Minister, with your presentation about the position in Poland as you see it. Thank you very much.
Lady Rose, Justice Rose, thank you very much for this wonderful introduction. It is my really great honor and privilege to speak to you and to present some of the challenges concerning situation in judiciary and rule of law in my country. I think that in order to understand and in order to grasp what is going on in Poland, it is important to present some historical facts. Basically, I think like the turning moment for Poland was 2015, because until 2015, more or less, we had different problems with, let's say, effectiveness of a judiciary, but in general, Polish legal system operated in a pretty good manner. In fact, it was acting in compliance with some basic rule of law standards. But in 2015, when the Law and Justice Party came to power, headed by Mr. Jarosław Kaczyński, a process of legal transformation and political transformation started in Poland. In first days, first months, there was I would name it, hostile takeover of the Polish Constitutional Court, and later on of number of different state institutions, such as public service, secret services, prosecutor's office, public media. And then in 2017, the government, the ruling majority in the parliament started to make a strong push towards curtailing independence of the Polish judiciary and restricting independence of different judicial institutions. I would like to say that between, let's say, 2015 and 2023, for 8 years, we have experienced different state practices that were undermining some basic tenets of the rule of law and the judicial independence, as well as the independence of the prosecutor's office. Fortunately, Polish lawyers, Polish civil society were quite good in using EU law as well as litigation before the European Court of Human Rights in order to stop the process of changes. So, in fact, we can say that European Union was to great extent learning on the basis of the Polish example how to use properly procedures for the rule of law compliance. And thanks to this, some of the practices that have been implemented over those years were limited when it comes to their extent and their impact on the Polish judiciary. And also, I would say Polish judges became quite significant figures in fighting for the rule of law. Just to give you an example, 3 years ago, we had a very symbolic march in Warsaw, which was called March of 1,000 Gowns, when representatives of different EU member states and not only were participating in a solidarity protest with Polish judges against all those different changes. But I would say that those changes resulted in a takeover, political takeover or political control or intimidation of certain institutions such as Constitutional Court, Prosecutor's Office, but also a leading body responsible for judicial nominations, which is the National Council of Judiciary. Moreover, in this period, a number of people decided to, let's say, take opportunistic advantage of certain professional choices that opened in front of them by, for example, accepting nominations to judicial positions by this National Council of Judiciary that has been, as I said, politically hijacked. Nevertheless, because of the pressure of the EU, because of the use of different measures, in 2023, the democratic coalition of three political groups won parliamentary elections. So elections took place on 15th October 2023, and on 13th December, 2 months later, Donald Tusk, as the Prime Minister, formed the government of Poland. And I was entrusted with the task of making changes in the Polish judicial structure and in general in so-called rule of law recovery. Please note that one of the major, I would say, problems is that although the new government has a parliamentary majority, it is quite difficult to unwrap some of those changes because the legislative process is still, at the end of the day, controlled by Mr. President. And President Andrzej Duda, who has been affiliated always with right-wing party, with the Law and Justice Party, or at least was supporting some of those reforms promoted by the Law and Justice Party, is not very much in favor of making some significant or crucial changes in the Polish judiciary. That is the first problem. The second problem is that although there is a power, there is a energy to make different changes in Poland, still there are a number of people who are situated in different institutions, such as Constitutional Court, National Council of Judiciary, or they work as court president. So basically, the big question is how to make those changes, and basically how to get out of this illiberal system of government with limited resources. And that is the challenge I am facing on a daily basis. The next problem is that we have to do those changes because otherwise we cannot be in compliance with the EU law and with the jurisprudence of the European Court of Human Rights. There is a huge expectation from the Polish society that those rule of law changes appear, although Polish society is not that much, let's say, acquainted with the fact that you cannot achieve all the purposes in a situation when there could be a legislative problem at the end. I mean here, Mr. President, who may veto some of those laws. And I think there is another important problem is that this process of changes lasted for 8 years. And right now we have just limited period of time to unwrap some of those negative problems in the Polish society, also some bad practices that have been implemented over years. So, and if you try to explain to people that, listen, it was 8 years and you cannot just unwrap, you cannot undo some of those negative changes within 6 months, it is something which is not very much understood because this level of expectations is quite high among voters of the Democratic Coalition. But please note what I'm saying right now is just about institutional side, and basically this institutional side should be about bringing typical separation of powers and independence of the judicial power from executive and from executive branch. Second, it should be about some, transparency and accountability of different state institutions. But we have here another side of transition, which is the process of accountability for past abuses. Because this process of building for 8 years of illiberal democracy was not just, let's say, a sophisticated process of changing the method of operation of different institutions, but it was just a kind of a very strong political game that involved a huge abuse of power in the context of in order to accumulate different means of impacting people and controlling the political situation in the country. I have once written an article in which I was portraying the system of government in Poland to the system of competitive authoritarianism, there is a theory of Stephen Levitsky and Lucan Way, which says that it is the system in which you have all the democratic institutions, but they operate in such a way as to bring positive results for those who are in power. And basically that is more or less how different state institutions work, like secret services, like prosecutor's office, state-owned companies, like the government, that there was a lot of different mechanisms that were benefiting the ruling party. So right now, what people expect, and basically what is the part of the transition, is the huge accountability process. And in order to make this accountability process, you must use different instruments that are at hand, such as investigative committees in parliament, such as a tribunal of state, which is the constitutional organ responsible for adjudicating cases concerning constitutional responsibility, or simply prosecution service that should that should prosecute different cases concerning abuse of power. And just to give you some idea about the challenge, please imagine that I serve in the position of the Minister of Justice, and at the same time, I am responsible for some process concerning auditing, accountability, concerning the use of so-called Justice Fund. Justice Fund was a special unit created within the Ministry of Justice that was devoted to help victims of crimes. This fund was in the amount of 100 million euro per year, and some portion of this money has been just quite openly used for political purposes with some ignorance towards procedures, without complying with some basic rules, with some situations that could be just regarded as a stealing of public money. So the situation right now is such that there are 3 persons, including some former managers of this fund, that are right now in pretrial detention. I have just submitted a motion to lift parliamentary immunity to one of the parliamentary deputies, and some new motions to remove parliamentary immunity are going on. And it is just one of the cases, and we have a couple of other important cases, such as Pegasus spyware abuse, such as abuse of the money from the major state research institution, or the abuse of money from the Polish forests company or the major oil company. So what I would like to say is that all different state-affiliated entities were to great extent used in order to get either some private benefit or the benefit of the former party that was ruling. So this process of accountability is important because people, voters, expect that you will not only do institutional changes, but also that you will take care about that justice is done. That people will see that people who are regarded as those, let's say, perpetrators of abuse would face some responsibility. But here you have another challenge, which is that you cannot do this process of accountability and you cannot violate at the same time rule of law standards. So you cannot behave in a revolutionary way that suddenly, some people are arrested in order to make some kind of a show off and be attractive to the crowd, but simply you must do it in accordance with all the rule of law, right to court, fair trial, and right to defense and presumption of innocence procedures, which means that, once again, the level of frustration is growing because, if it is the new government, this new government should deliver, and people don't care, or they do not have that kind of a big understanding that compliance with procedure takes some time and that you cannot just do everything on one day. So it is a moment which is also regarded as one of the transition problems. And finally, please note that in order to do this process effectively, you have to, and in order to complete this process of the rule of law recovery, you have to take care about institutions. So at the end of the day, we must have a proper judicial review. Right now, the Polish Constitutional Court has a legitimacy, according to public polls, around 20-25%, and basically the Constitutional Court is just used as an instrument of some kind of a political game. You have a problem that there are a number of so-called beneficiaries of the system, which are judges that were appointed over last 7 years, over last 6 years. And the big question is what to do with them. Should they be still judges if their process of nomination was flawed, or should they be somehow vetted? But how to make vetting of judges in case they constitute more or less 1/5 of the whole Polish judiciary, when out of 9,000 Polish judges, you have more or less 2,000 judges that have been appointed over those last 7 years. And on top of this, because the previous government was dealing mostly with all different institutional changes, and because the former government was to great extent interested in putting the judiciary in this political spectrum in order to control what is happening in the judiciary, the government was to great extent forgetting about problems of court's effectiveness. It was not, it didn't conduct any proper dialogue with Polish judges, with Polish prosecutors. So one of the challenges that I face is how to, on the one hand, rebuild the institutional picture of judiciary, and on the other hand, how to take care about effectiveness and proper operation of Polish courts. And so, as you see, the challenge is quite significant, but I would like to add just one thing, because in that kind of a specific moment when you have faced erosion of democratic standards, you may ask a question, okay, but so what is like the yardstick? What is like the lighthouse for you in terms of changing judiciary and the rule of law structure. Unfortunately, for us, this lighthouse is jurisprudence of the Court of Justice and the European Court of Human Rights, and it is also the cooperation with with international institutions such as the Venice Commission or OSCE, with its office in Warsaw, Office for Democratic Institutions and Human Rights. So basically, in case of constitutional crisis, in case of a crisis of standards, we have to rely on existing jurisprudence of the Court of Justice and the ECHR and other international standards. And also in terms of changing reality on a daily basis in Poland, we have to create a trust with international institutions. And it seems to me that I'm just would say celebrate 6 months of being in the government, in the position of the Minister of Justice, and I think that we have managed, at least using limited resources, to regain some level of trust of the European Commission, because Article 7 of Treaty on European Union is not any longer in force with respect to Poland. So basically, Commission understands and appreciates the process of changes in Poland and has decided to agree that there is no any longer serious risk of further rule of law deterioration. And also, the EU recovery money has been unblocked with respect to Poland, and it was quite a substantial success to do it. So what I'm trying to do is to use the limited existing legislative possibilities in order to change the reality, in order to change practices on the ground, in order to guarantee that Polish judges may feel safe in their adjudicative role, and that they can safely use EU law and human rights standards to the benefit of Polish citizens. Thank you very much for your attention.
Well, thank you very much, Minister. That was an extraordinary tour d'horizon of the history of the difficulties that you're facing and the difficulty of balancing accountability and institutional change and the way that you're going around that. And what we hear from what you're saying is what we know in our hearts, which is it's quite easy to damage these systems, much more difficult to repair the damage in a way which is fair and shows accountability. You mentioned very interestingly how the EU institutions were learning and developing their human rights norms, using the Polish experience and assisting those who were seeking judicial routes to challenge what was going on. And that leads us very nicely to Christopher Vajda, who is now going to speak from the EU angle as to how they tackled these cases. But thank you very much, Minister, for your fascinating talk.
Thank you very much, Vivian. Thank you very much, Minister. I'm really delighted to have been invited to be here tonight. The first talk I gave for the Slynn Foundation was about 20 years ago, or possibly more, in Budapest just before accession. The start of my speech didn't go terribly well, because I said I was delighted to be here in Budapest in Eastern Europe, and I was immediately interrupted by the chairman and said, no, Mr. Vajda, this is not Eastern Europe, this is Central Europe. Now, I was particularly interested in what the minister said about how, and the point that Lady Rose has just emphasized again, how difficult it is to reverse the reforms, even though there has been a change of government in Poland. And in a way, that is of some relevance, because what I'm going to be looking at is, in a sense, what the European Court has done. But that's, of course, backward-looking. But as I will explain, that is relevant when one is looking forward as well. And I'm going to just look at some topics, effectively 3 topics. First of all, the court, when I say the court, I mean the European Court's case law on judicial independence, and then the approach to the Polish cases, and I'm going to look happily only at a few cases given the time, and also want to mention specific features which distinguish the European Court from other international institutions. Now, looking at the first point, and I think this is important because of the politics that's involved, that the courts, and when I talk about the court, I'm talking about the European Court in Luxembourg, not in Strasbourg, on judicial independence predated the threats to judicial independence in Poland. So it is not right, as has been sometimes suggested, that this case law was, as it were, dreamt up or developed simply to deal with, if I can put it, the Polish problem. Now, I have a sort of small footnote in this history, which I will just elaborate on. I did a case over 20 years ago for somebody called Graham Wilson, who was a member of the bar, English bar, who wished to establish himself in Luxembourg. And there was a directive which provided for establishment of lawyers. And what the directive was silent about was whether or not you needed a language requirement. And Luxembourg in those days was somewhat restrictive, and so they put in a language requirement. And being Luxembourg, it was not just one language, it was 3 languages. And the text is Il faut maîtriser les langues nationales, which is, of course, French, German, and Luxembourgish. And just to raise the hurdle a little bit, there was an appeal procedure because the person who actually examined you were your competitors. I mean, it was the bar that carried out the language. You didn't have an independent language assessor. And prior to this change in the law, there was an appeal that you could institute from the decision of the bar, and the appeal body consisted of 3 judges and 2 avocats. But they decided not only to, when they introduced the language requirement, but just to tweak the composition of the appeal body, so it became 3 avocats and 2 judges. And one of the points that we took in that case was that was contrary to principle of effectiveness and independence in EU law, and we won on that. That was 2006. Now, if you fast forward to 2018, which was actually when I was in the court, and indeed, when I arrived at the court, life was very much dominated by the euro crisis because people thought that the euro was going to fall apart. And we got a lot of cases from various countries in southern Europe where there'd been certain measures taken, effectively austerity measures, to effectively stabilize the economy. And one of those cases was a challenge by Portuguese judges to a salary cut that was imposed by the Portuguese government pursuant to these austerity measures. And I remember, some of you may know that at the court you can deal with a case in various ways. The most grand way of doing it is send it to the Grand Chamber. You've got the benefit of 15 judges. The way that you kick it out as quickly as possible is you make a reasoned order, which there's no hearing, nothing, it gets kicked out. And every week, one would have a weekly meeting. All the cases that came into the court would be on the agenda. If anybody thought that the case should be disposed of procedurally in a different way than had been proposed, there'd be discussion. And in fact, this case, I remember quite distinctly, we had this meeting at 5:30 on a Tuesday afternoon. The proposal was that this was going to be dealt with by reason order, because there had been a whole series of cases to this effect. And there was then, I can't remember, a judge had said no, he or she wished to discuss that, so it was then put on the agenda. And as a result, and it's one of these extraordinary things, it went from the lowest form right up to the Grand Chamber, and it became a leading judgment of the court, because the court, the question was, what did EU law have to do with this at all, a cut in the judge's salary in Portugal? And the court said, well, EU law is relevant because Article 19 of the TEU requires member states provide remedies sufficiently to ensure legal protection. and Article 47 of the Charter, which to some extent mirrors Article 6 of the Human Rights Convention, requires access to an independent tribunal. And that was, I mean, in the end, there was no question that what was being done in Portugal was compatible with that. But I mean, that was interesting because that was just, and coming back to what the minister said in terms of chronology, this was when, in fact, one already was aware that there might be difficulties in Poland. Now, then that brings me on to the next point. I looked at the court's website, I may be slightly out of date, but last week, and there have been 26 cases from Poland between July 2018 and 2024. And happily, both for me and you, I'm not going to deal with all of them, I'm just going to look at 4 of them. But again, I come back to the point that this is not simply a Polish problem. There are also cases concerning Hungary, Malta, and Romania. And indeed, while I was still at the court, one of the very big issues that came up quite often in relation to the European arrest warrant was the requirement of independence for the public prosecutor. And there are a number of cases, I'm not going to mention them tonight, where we said in states in Western Europe that Sweden and Germany, for example, that there was not sufficient independence. And those cases themselves were influenced by what was happening in relation to Poland. Now, before looking at these cases, I just want to mention what I think are some specific features of the EU regime that distinguish it from other international tribunals and has probably ensured that the effect of its judgments has been quite considerable in Poland. The first point is obviously that you can seize the court in Luxembourg without the need to exhaust domestic remedies. And we'll look at one of the cases, and indeed the minister referred to the march of Polish judges. One of the leading cases in Luxembourg was a case actually brought by 3 judges, Polish judges. The second specific feature is that one has public enforcement by the European Commission. As you're all probably aware, the Commission can bring what we call infraction proceedings. And in 2 of these cases, which concerned the disciplinary chamber that was set up, not only did the Commission bring infraction proceedings, but they brought proceedings for interim relief to suspend some of the Polish measures. And in one of the cases, where Poland was not complying, the Commission went back to the court, and the court imposed a daily penalty of €1 million a day, requiring Poland to comply. The third feature is obviously private enforcement, which is via the Article 267 mechanism. We'll look at one of the cases I'll refer to it concerns that. And then the fourth feature, and this comes back to what is really important in relation to what the minister has said, is, of course, you're all familiar with the direct effect of European law, which requires judges to set aside domestic legislation which is contrary to EU law, and that arose in, all these cases, but one of them in particular. And then the last 2 features, which perhaps may not be apparent to this audience, but I think are very important, and perhaps if we look at it more in the general European context. I've mentioned the European arrest warrant, and the European arrest warrant, for those of you who don't know, is a system within the EU. It was set up, I think, at the beginning, 2002, something like, which would replace the traditional extradition system. And it works on a principle that is well known to people who practice in the field of European law, which is mutual trust. And what happened, and I'll look at one of those cases, is that courts in countries other than Poland asked questions to the court in Luxembourg, well, in the light of what's happening in Poland, can we still trust the Polish judges? Can this person still be extradited to Poland? And then the last specific feature of the EU, and this will be the last case I refer to, and this was quite attracted a lot of publicity and there's a lot of ink spilt about it, is whether, and indeed that's what the European Union did, they introduced what was called the conditionality regulation, which is that that Poland and indeed Hungary are large recipients of EU funds, and so the regulation was adopted which effectively attached, if I can put it like that, a rule of law condition. And that regulation was challenged by both Hungary and Poland. That's the last case that I will deal with. Now, just going through very quickly the four cases that I'm going to mention out of the 24. The first case, which is a public enforcement case, so not surprisingly, is called Commission in Poland, concerned the lowering of retirement ages, because one of the first measures that the Polish Law and Justice government took was to lower the retirement age for Supreme Court judges to 65. In fact, although it changed a little, it was only prospective. Originally, it was tended to be retrospective, but it was prospective in effect. Now, but what they did was that they said that this was subject to if a judge wished to continue beyond 65, he or she could make an application, as it were, and had to produce a certificate stating that his health was good enough for him to continue. But that decision as to whether or not he should continue was to be taken by the President of the Republic of Poland. And that's raised fairly and squarely the principle that we're all very familiar with in this country, which is the principle of irremovability of judges. What the court said is that that principle requires judges to remain in post provided they've not reached the obligatory retirement age or until the expiry of their mandate. And the court, because obviously there's, particularly in European law, nothing is always quite black and white, they said that that principle was not wholly absolute, and there might be exceptions, and this is familiar to those of you who know anything about EU law, as you call it, exceptions which were warranted by legitimate and compelling grounds subject to the principle of proportionality. They didn't. The argument that the Polish government put forward was, well, actually, and this might resonate with some people in the audience and not for others, is, well, actually, it'd be a very good thing to reduce the age of retirement to 65, because that means that judges are more, their average age is more like the average age of the general population in Poland. That argument, not surprisingly, didn't find favour with the court. Then going to the next case, which is the case I mentioned about, this is where the three Polish judges themselves were litigants, and they challenged their compulsory retirement from, in I think one case the Supreme Court, and in two other cases the Supreme Administrative case. And the procedure had changed slightly from it, because by this stage the body that you appealed to was a body that had been altered by the government. It was the KRS, but English translation, the National Council of the Judiciary of Poland, and you had to get a favourable opinion from them. They, in these cases of the three judges, they issued an unfavourable opinion. And the question was whether this body that had been set up, satisfied the requirements of independence, which is in Article 47 of the Charter and Article 19 of the TEU. Now, again, it's quite interesting. It's interesting not just for people in Poland, but I mean across Europe. One of the arguments was why it was not independent was that the judges were appointed by the president, political appointees. the court rejected that argument because they said the mere fact, and of course we can think of, if we go across the Atlantic, judges are appointed by a politician doesn't mean that there's independent. What is important, obviously, is once they're appointed, they then need to be independent. So that was the crucial factor in that case. And they gave various indications which sort of they left the final decision to the Polish court, but the whole circumstances rather suggested that this body was not independent. I'm now coming to the third case, and this comes back to the European arrest warrant issue that I arose. And again, this shows the dynamic of how things develop in courts, because, in fact, while I was still at the court, a Irish judge, but it may have been the Irish Supreme Court, actually asked the Luxembourg court whether or not somebody who was resisting his being transferred to Poland under an EAW, and he relied on the fact that he said, well, of course, I'm going to be put into this big black hole in Poland, and that's completely contrary to mutual trust and the principle of law. And in a somewhat carefully crafted judgment, the court, this is just to have the timeline, July 2018, said that what the Irish court had to do, a two-step analysis, which is, first of all, you have to look at whether there is a systemic or generalized deficiencies in the member state, and then secondly, whether or not such deficiencies would be liable to have an actual impact of the trial of the individual concerned. So you can see it was a balanced judgment. Now, obviously, neither lawyers nor judges are immune to how things develop. And a Dutch court in 2020 made another reference with the exciting names L and P, because everything's anonymized in Luxembourg. And what it was really saying to the court is, well, we've had this Irish case in 2018, but since then there's a lot of water that's flown on the bridge. We've had the AK case that I've mentioned and so on. So really, we in the Netherlands, we really feel we can't trust the Polish judges. Shouldn't you effectively change your approach? And the court resisted that invitation. But that illustrates the fact that when one is looking at a body like the EU, it's not just a question of the Commission and Poland, it's also looking at the horizontal relationship between judges. And I now come finally to the last case, which is the conditionality case, which was decided in February 2022. And of course, this again, if you're looking at financial pressure, it was very, very significant because Poland and indeed Hungary are substantial beneficiaries of EU funds. And so what happened in this case is that in the financial regulation, a conditionality clause was added, which provided for the protection of the EU budget in cases of breaches of the principle of rule of law in a member state. And this was challenged, as I say, by Poland and Hungary, and I'm just going to focus on two grounds of challenge. The first was a lack of legal basis, and the second was a breach of the principle of legal certainty, because the regulation didn't define sufficiently what the rule of law was. So it said you can't, this is as you legal certainty is a basic principle of EU law. Perhaps it won't be a surprise to you know that the court dismissed both those challenges. On the legal basis, what the court said, the actual legal basis was an article in the treaty, I think it's Article 325, which permits the EU to provide funding to member states. And what the court said is that the common values on which the EU is founded, such as the rule of law, justify mutual trust. So you get this phrase, which is so, I can't overemphasize how important that is. And that since compliance with the rule of law is a condition for the enjoyment of rights that member states have under the treaties, the EU was entitled to impose a conditionality requirement pursuant to the powers to make payments. And then on legal certainty, what the regulation referred to rule of law, and then it said such as, and this was effectively one of Poland's points, where it's not sufficiently clear, but one of the such ases was access to justice by independent and impartial courts. And what the court said basically on this is, well, actually everybody in the EU and indeed in Europe knows what we mean by the rule of law, and indeed if you need to have any further assistance, have a look at some of our case law where we've actually set this out. So that was dismissed. So I think by way of conclusion, I can say that, and obviously this is an area which highly political in Poland, indeed in other member states. But whatever one's views on the politics of it, these cases show, in my respectful submission, how courts, and I've focused on the court in Luxembourg, can play a valuable role in applying and developing fundamental principles. And in the context of the EU, it's the Charter and the treaties. And they are also able to ensure that changes to the constitutional architecture of courts in member states need to respect those fundamental principles. Thank you.
Thank you very much, Christopher. That's a very interesting overview of the cases, and it just shows how incremental legal development, I'm sure if you had in 2015 tried to predict the contexts in which these issues would come before the court, the disparate nature of European arrest warrants on one hand, conditionality regulations on the other hand, the reduction of judicial retirement ages, it's always interesting to see what actual dispute it is that then generates this development of the case law. You mentioned at the beginning of your speech and throughout that this is not wholly a Polish issue, both before and during these developments we've been discussing. There have been other European aspects to this. And if I can now invite Charles Crawford to put these issues in a European context. Thank you.
I haven't done anything like this for a while, so excuse me if it's a bit incoherent. I remember ages ago talking about the European Union with one of my former ambassador colleagues, and he said, the problem with you is you always go back to first principles. And I felt like saying, well, what principles do you go back to? Second, third, fourth? I mean, what are we dealing with here? So I want us to go a little bit back to first principles, because obviously both the minister and the last speaker really know this stuff in a way that I don't. I mean, I'm not a practicing lawyer. I'm not close to it anymore. I was in ambassador in Warsaw, 2007, different world. But I think when you're talking about all these rule of law issues, where do you start? And we started here in 2015. You went back a bit earlier than that. I'd like to go back to Lenin. Let's get to first principles here. And the great slogan of Lenin was "Kto kogo," whom, who does what to whom, who is up, who is down, who's kicking, who's getting his bottom kicked. And this was the great slogan of communism, whom. It was on Soviet posters. And really what he's getting at is something actually quite powerful, even though he's a ghastly communist, namely, who decides? And who decides who decides? And who decides the rules for deciding? And who keeps the files where you keep the rules for deciding? So you can start looking at all these issues in very, very micro ways to try and find out what exactly is happening. And in the bigger picture, this comes back to what I did at college years ago when I did my jurisprudence course, the hierarchy of norms. Some of you probably remember the hierarchy of norms. But it's all about the idea that rules come from rules, and rules come from rules. And where is the original? Where does it all come from? And you look at that sign over there on the wall. Gresham College, Thomas, 1597. We don't really think about these things very much in this country because stuff has just been here for centuries. It's around. The Queen's been around, the monarchy's been around, Parliament's been around, Magna Carta. You know, we don't really have to think about it. And the one time we did have to think about it, we blew it, I would argue. And that was when communism ended, because all of a sudden you had quite a clear break with these great edifices of power and rules and the oppression and whatever, which had been going on for 40 years. The minister said, look, this has been, I've got to try and unscramble 8 years worth of this. Well, okay, how do you unscramble 50 years of communism? And all the illegitimacy and the murder and the torture and everything else that went on with that. So anyway, communism came to an end. And, you know, we all ran around. I was there, you know, trying to work out what to do. You know, how do you help these countries emerge? And the Slynn Foundation was set up, I think, pretty much by George Dobry, wasn't it? It was one of his ideas to get it going, a Polish judge, a Polish origin judge in the UK, who wanted to bring British judicial wisdom to this situation. And I would say basically we failed, because in all the programs, the World Bank programs, the know-how fund programs, there just wasn't enough stress on the rule of law issues and what that really means. Yes, okay, independent courts, a lot of things. But the rule of law isn't just about things, it's about the way you look at the world. It's about integrity. It's about fair play. It's about balancing things which are very subtle to balance and can't be measured. And on the whole, we didn't have any of these things in our programs. And I remember when I was ambassador in Belgrade, minister, I was very interested in cigarette smuggling, because cigarette smuggling is a big deal. And you look at what's actually going on with cigarette smuggling. A lorry load of cigarettes, which is somehow pinched and smuggled into a country, that's worth $250,000. And you might get 3 or 4 of them every afternoon crossing into Serbia or Kosovo or that part of the Balkans. Now, our aid budget for Montenegro would, say, be £5 or £6 million a year. You can do some stuff with that, some Slynn visits, there's bits and bobs you could do. But it's nothing compared to the cigarette smuggling budget. So if a judge in Bosnia is paid €400 a month, and 1 truckload of cigarettes, 1 truckload is worth €250,000. With that truckload, you don't buy a judge, you buy the legal system. And I said this to our colleagues from DFID, as it then was. They said, it's not a priority sector. Well, okay, but then what do you think you're building all this on? I said to them, what you're really saying is you're putting our aid into a bucket with a huge hole in the bottom. That's what you're actually doing. Anyway, so that was the transition from communism. I think there was a major opportunity missed to really get the rule of law as a sort of theme of public discussion, really internalized and operationalized, and to help bring our wisdom to bear, not that we're always going to be right. Talking about the EU, Poland and the other countries apply to join the EU, and they get in, and Britain pushed very hard for that to happen. We were right at the forefront of that big change. And there's this phenomenon called othering. Have you heard of othering? Othering is where you sort of define the world so that this is the good bit and over there are others. And I think initially Central Europe, Eastern Europe, we weren't quite sure where it was even, what to call it. It was others by the EU. Yes, they were in, but they weren't. Who are these people? They should just mind their P's and Q's. And the famous high water of this was 2003, when the French president was very upset about Poland and the other countries supporting America in Iraq. And he basically said, you've missed a good opportunity to keep quiet. They've been irresponsible and ridiculous. And he said, when you're in the family, you have more rights than when you're asking to join and knocking on the door. In other words, these countries were sort of outside peering in, and they should just mind their own business about what's going on where the grown-ups are. And this attitude sort of carried on, and it went on for a long time with Ukraine. And we had this with with Ukraine. Is Ukraine a European country? Now, I think most of us would think, well, yeah, basically. I mean, it's not Asia, it's not Africa, where is it? But France went out of its way for a long time to say, no, Ukraine is not a European country. Because if we tried to treat Ukraine as a European country, it would meet the Copenhagen criteria, and then it in principle would be able to join the EU, and what would happen to the common agricultural policy and French farmers? So Ukraine was othered. And this went quite deep, you know. When I was in Warsaw, we had a meeting of EU ambassadors. There's a tradition in European countries that European ambassadors meet to chat about what's going on in that country without the host government being there. And I remember the French ambassador saying, oh, well, look, we're reading these very disturbing reports about anti-Semitism in Poland. You know, perhaps we should recommend as a group of ambassadors that Brussels write a report about this problem. So I said, well, that's very interesting, because actually I'd seen in the paper that Jewish cemeteries are being vandalized in Paris. Do you think we should get them to write a report about that instead as well? I mean, what are we dealing with here? And the whole thing was just dropped. But there was this feeling that we're looking through the microscope at Poland, and it just needs to sort of be where it is. So that was the sort of context back when I was still ambassador, pretty much. And things obviously have moved on a lot since then. But listening to the discussions, I mean, you know, you're really... some of these things are pretty existential. In other words, are European countries, are they sovereign states or are they county councils? What are they, actually? And if there's one thing the European Union wants, it's more Europe. And if it can't get it one way, it'll try to get it another. And I don't know, but listening to this as a citizen, it seems to me a sovereign state might reasonably decide when judges retire. That doesn't strike me as being unreasonable. Just like it decides how much they get paid, decides their conditions. And all of a sudden, it seems that the European Court is saying, no, you know, this is something for us to decide, not you. And if you're putting money into the pot and getting money out of the pot for the EU, they can't get it in the treaties so that there is conditionality, so they do it by a regulation. And this means that all of a sudden your laws at the EU level are treating countries more like county councils than they are like sovereign nations. Now, all this is fine as long as you get away with it. And what you're now seeing is European elections the other day, people aren't necessarily happy with the package. And that's fine. It's all fine until it isn't. Where I found the Kaczynskis quite interesting as people when I used to meet them. This is long when the former president was still alive. You know, he would come along and talk to the EU ambassador, and he would say, look, one of the things we're being asked to accept is Europe, take it or leave it. Even though, because of Yalta and because of policies adopted by the UK and all the other European countries, we were excluded from those discussions. So there's the legal acquis, if you like, for Europe. You know, you have to accept the rules which have passed, fair enough. But there's also a sort of psychological acquis as well, a sort of progressive worldview, which Poland, he felt, was being obliged to sign up to in a way which he found very difficult. And I'm sure part of the what's been going on here is a big pushback by Europe against that argument, that Poland has a right to somehow carve out a separate social identity, if you like, from the rest of the EU. But anyway, look, it doesn't matter now, because Poland has moved on hugely. Poland has gone from bread queues and, you know, poverty, terrible, nothing. The economy of Poland at the end of the Cold War was less than $1 billion. That's like the small change of an Apple rounding error. That was the economy of Poland. Poland is now one of the 21st biggest economies in the world. You know, Poland has arrived. I was there the other day. You drive from Warsaw to Gdansk on the new EU-funded train. Pretty impressive. Poland's doing very well. So Poland as a force, Poland's got Europe's probably best army now, almost Europe's only army. So this is something, you know, force to be reckoned with within the EU. I just think that when you look at the European elections we've just had, there's been a great sort of panic that the hard right, the far right, the radical right, whichever adjective is now the fashionable one, has sort of come into the fore. But you can be pretty sure that if Le Pen takes over in France, and that would be a pretty major challenge to the rule of law compared to anything we've seen in Poland on lots of levels, not just the rule of law, but to the, if you like, the spirit of the law. This would be a major challenge. Will these EU measures be brought against France? And the answer must be probably not. Why? Because France pays. That's what's going to happen. And we'll see whether or not that people can rustle up the legal firepower to try and bring France under control, but I doubt it. So that's where it is, really. We're seeing in Europe, an unease about the level of, about the degree of Europeness which countries have to put up with, and the practical effects of that. And Poland is, a great a drama in all that, and it's clearly had a lot of effect. It just remains to be seen whether, when we look back at this 10 years from now, what will we think? Will we think that this was just a blip, or will we think it was part of a deeper crisis of some sort, and Poland was just a pigeon in the mine? What's the word? What's the thing where you have in the mine? A cuckoo or something? A bird in the mine, breathing the gas, and that it's the first to warn. That's right. It warns you that there's a problem on the way. What will we be dealing with? Thank you.
Thank you. Yes, I think thank you very much to all our speakers. It is wonderful that we're having this event in this hall, which, as you say, goes back to 1597. But I think what we learned from all three of our speakers is that the rule of law is not something that you can take for granted. It's hard work. It's hard work that a lot of people I know in the audience are contributing to. And that personally, I salute you, Minister, for the work that you are undertaking to bring Poland back into the fold, whatever that fold is going to look like. Now I ask Stephen to invite questions from the audience.
Thank you, Vivian. I'm going to begin the questions myself, chairman's privilege, and I was really intrigued by what Charles was saying. Underlying the regulatory arrangements in Europe and the formal legal processes, there is a cultural tension. And I think that's the essence of what he was saying. And my question with that in mind is really to Minister Bodnar. I have taken it that the changes brought in by the Law and Justice Party were, in the Minister's view, not merely the exercise of sovereignty, not merely the function of setting a retirement age for judges, but interfering with the independence of judges, the conditions of judges, the way the judicial system works, in order to achieve political ends by other means than election and legislation. So that, as I understand it, is the approach taken since the recent elections, that it's not merely change in the judicial manning and change in the judicial system to improve the product politically neutrally, but to do so for political effect. Now, there seems to be a paradox then facing this government, and it's here I'd like the Minister to comment. If it is the case that there was a distortion of judicial function and a diminution of judicial independence through the abuse of executive power and an abuse of the executive control over the legislature, how do you correct that using executive power and using the executive control over the legislature? How far does that go? What are the checks and balances in using essentially ministerial power? And particularly, if it's correct that about 1/5 of the Polish judiciary was appointed by Law and Justice over the 8-year period. Now, are we to assume, does the minister think that all of those will be judges who should not have been appointed, who were appointed for their political effect, to distort the system? How do you manage the turning back of those changes without itself becoming tit for tat? And then looking to the future, setting up a system whereby the judges are changed and altered and put in a false position every time there's a major change of government. So that's quite a long question, but I think the essence of it will be clear.
You are right that being in the executive, I have limited powers. And I know that the scope of what I can do right now is in fact limited by the legislation and by those opportunities, possibilities that exist in the legislation. So, for example, I know that I cannot do anything, to be honest, regarding vetting of judges as such, because I cannot do it without a legislative act. So I have to wait, most probably 1 year, and to use this 1 year in order to negotiate, in order to prepare the legislation that would provide for the proper vetting procedure for judges, and then to wait for the president that would be able to agree on this law. But I know that I have to do it in accordance with Council of Europe standards. So you must provide those people who are subject of vetting with a proper procedure, with right to appeal, with remedy, and so on. And you cannot, so it is a little bit like a difficult time, because at the same time, all those people are still judges, they adjudicate cases, although their position could be regarded as dubious from the point of view of the Court of Justice jurisprudence. But in meantime, I have some possibilities of doing certain things regarding judges. Like, for example, under the Polish legislation, it is the Minister of Justice that is responsible for appointment and has a certain role in dismissing court presidents. Court presidents are pretty important people in the Polish structure. So you can make this procedure in a situation when there is a college of judges from a given court agreeing on dismissal of the court president. And apparently, some of them feel that there is a little bit like the wind of change coming, and some of those collegia of judges agree on that kind of a process. So what I do is that if there is this kind of an agreement that the president of the court should be exchanged, and I have this, let's say, possibility of that college of judges may agree on my procedure, then I dismiss court presidents, but later on, interestingly, I do not appoint them using my own discretionary power, but simply referring to the Venice Commission recommendations. I ask college of judges, I ask all the judges from a given court to give me 2 free candidates for the position of the new court president. So kind of I limit my own power, because then I select a new court president only of those who are appointed by, who are indicated by me by all the judges from a given court, although I do not have a obligation to do it. Another measure that has been used by me, it was quite interesting, and it refers a little bit to the EU law, is that, for example, in this period of those serious abuses, it is important that we take control over the use of the EU money. And there is an institution which is safeguarding EU money, which is the European Public Prosecution Office, European Prosecutor. And interestingly, you can join the European Prosecutor without changing the legislation. It is the enhanced procedure. You are just sending a request to the Commission. Commission is verifying this, then you are part of it, party of it. And it was quite symbolic for the EU that basically we are going forward with this measure. Just last sentence. Referring to previous commentators, I would like to say just one thing. For sure, it was for the European Union to learn a new method of controlling compliance of, let's say, judicial independence standards in member states. This Portuguese case was extremely illustrative because it was a little bit a transformation moment for the EU, to be honest. And I perfectly agree here that European Union kind of over those years extended power of controlling judiciaries in the member states. But for us, it was the only chance for the judiciary and for the democracy to survive. Without this EU compliance check, we would not have a chance to, we would basically end up as Hungary is doing these days, okay? We would end up as a typical authoritarian country in the middle of European Union. But interestingly, please note, I think this case of retirement age was interesting. It's very illustrative case because this case was not about whether we should have a retirement age of 65, 70, lifetime, 75 or whatever. It's still the matter of domestic competence. But simply what the Court of Justice said, sorry guys, but if you impose that kind of a measure, you cannot do it to existing judges. You cannot tell them one day that, okay, sorry guys, your retirement age was 70, but from now on, your retirement age is 65. And surprise, surprise, it applies to the first president of the Supreme Court. So Madame Gersdorf had to basically go compulsory for retirement, despite the fact that she was having a constitutional mandate. So that was the problem. Abuse of the legislation in order to achieve a certain political effect. And that was this moment when the EU intervened. Thank you.
Thank you very much. Now, we've time for a couple more questions, I think. Yes.
Ian Cliff, I'm a trustee of the Slynn Foundation. I'm, like Charles, a former ambassador. Unlike Charles, I'm not a lawyer by background. But can I explore a little bit more, Minister, this point you made about some sort of analysis of the performance of judges, vetting of judges? Would you, I know you said you'd have to wait for political developments before that could happen, but would you have to vet all the judges or only those appointed under law and justice? I'm sure you know that there have been various attempts at vetting judges in the Western Balkans as a prelude to them eventually joining the EU, and this process hasn't gone terribly well for various reasons. Thank you.
Thank you very much for this question, because it brings me a little bit toward what has been said by Ambassador Crawford regarding the situation in the Balkan countries. Please note, we are this very special country, quite unique, that we do not have as such corruption among judges. You know, if you compare Poland to, let's say, Ukraine, it is a fundamental problem. USAID or International Monetary Fund activities about Ukraine are about, let's say, checking judges from the point of, or future judges from the point of view of being prone, from being free from some corruption practices. And in Poland, I think it was one of the great successes of the transformation that more or less proper remuneration plus pretty nice retirement benefit was a little bit like a guarantor of the efforts for judges, and they didn't get into corruption activities. Which means that if you are making any vetting, you do not vet them from the point of view of whether they are, morally okay or not, but you have to vet them from the point of view of how they have been appointed. So please note, after 2018, the new National Council of Judiciary has been created, which became a highly politicized institution. It was quite obvious to everybody that this institution was in order to pack in the judiciary with, let's say, more or less loyal, obedient, or at least not that very much constitutionally oriented judges. And over this time, between 2018 and 2023, there were like number of people that were appointed to judicial positions or that were promoted. So more or less 50% out of those, so more or less like 1,000 of them were just judges who were judges before, and they were just promoted in kind of opportunistic way to higher positions. There were more or less 500 judges that have been graduates of the National School of Judiciary, kind of, rookie judges, and they didn't have any other option than just to get a promotion from the, to become a judge after the finishing of this national school. And the third category were like people from other professions, like barristers or members of academia, prosecutors that decided to become judges. And then the question is, okay, but even if you have this 2,000, to what extent their application and their willingness to become a judge was, let's say, politically controlled, or was it just kind of a, let's say, like a daily opportunism? Like, you have a, let's say, better chance to be promoted. You do not want to wait number of years for this promotion. You are this, let's say, labor court judge who is already 15 years of experience in the district court, and you would like to finally go to the regional court and to, to have some kind of a promotion. That maybe there is something wrong with this National Council of Judiciary, or there are some, judges, dissidents who are protesting, but still, you are closing your eyes, you are going forward. It doesn't mean that you are, betraying, that on a daily basis you are adjudicating in some political cases. You are just taking advantage of this, let's say, life opportunity, okay? So that is basically what you have to evaluate. So what was, to great extent, motivation, whether there was some kind of a political manipulation behind your promotion, whether you kind of, really betrayed some values in getting this, or was it just a kind of a situation that maybe you made a mistake, but simply you didn't really, at the end of the day, violate some basic principles of your judicial independence? Because you have these days in Polish judiciary a number of judges who are named as so-called neo-judges, we name them like this, that are performing pretty okay without any problems. But still you have this judicial, you have this flaw in the nomination, which is signaled by the Court of Justice, European Court of Human Rights, and you have to somehow resolve this flaw in order for all those judges to have like equal status. And that's why we are just designing this model how to do it properly. But please note, it is like a very innovative thing, because there was one country that had a similar problem with this, let's say, flawed nomination, which was Iceland. There was a case Astrason against Iceland, and they have resolved it perfectly without any problems. But it concerned only 4 judges. Okay, we have 2,000. Okay, and to do it on such a massive scale is quite a precedential and innovative thing, but I hope that we'll deliver at the end of the day, we'll create a little bit like a new practice of that kind of a situation.
Well, thank you very much. I think we're going to have to call things to a close because we've slightly overrun our time. I want to thank all of our speakers very much for their contributions. This is a really interesting topic. It's close to the heart of the Slynn organisation because I think, as already been mentioned, the organisation grew from the mind of George Dobry and the work he did with Gordon Slynn. And by far and away, the first major field of operation of Slynn was in Central Europe, and particularly in Poland. So it is close to our heart. It is right at the core of what Slynn wishes to do, without being critical of anyone, to offer support and help wherever that may be valuable around the world now. And that's why we're interested in what is happening in countries like Poland. So thank you all very much indeed. We'll bring it to a close. For those who are interested, within 2 or 3 days, the recording of this meeting will be on the Slynn website, and anyone who wasn't able to be here can look at it. There's free access. So thank you very much. Thank you to Lady Rose, and good evening to all of you.
Thank you very much. Thank you.